Okay, at this time, I would like to call the January 14th, 2016 BOA Board of Adjustment meeting back into order. We took a recess January the 14th. This is still the same meeting going on, and it is now January the 28th, and we are back in order. As of the end of the last meeting, Mr. Woody had put on the staff findings. Mr. Plumley had presented his professional witness. Mr. McRee had a lot of objections going on with the witness. We understood that the witness had time constraints, and Mr. McRee, you will be allowed plenty to address your objections to his testimony as we go further.
Yes, thank you.
Okay. I would like everybody to make sure their phones are silenced. And before we start, is there any discussion from the board or direction that we need from our attorney?
No, sir. You just need to call back in order from recess.
I did
Okay.
already call us back in order from recess. So, Mr. Plumley, you were finished with your professional witness that was here.
That's right. You were kind enough to take him out of order, and I believe Mr. Woody was giving or had given his report. We brought Mr. Pastor in, who testified. He was from Oklahoma. He's going back to Oklahoma. So I guess the proper order is back with the county at this point to proceed with its presentation.
That would be correct. We took a witness out of order, but the evidence is with the county.
Okay. Mr. McRee.
I'm trying to recall, I think Mr. Woody had completed his testimony before
Correct.
the expert.
Yes, sir.
I think that would be all the county intends to put on. Of course, again, the burden is with the applicant. Although I would note that there is a member of the public that's here. I don't know at what point in your proceeding you would like to.
I would like to suggest it would be appropriate at this time to allow cross-examination of Mr. Woody.
Yes.
And then the member of the public would certainly be entitled to testify. Do you intend to testify, ma'am?
Yes.
Would you give us your name, please?
Nancy Collins.
All right, Ms. Collins, would there be any other witnesses from either side?
Yes, yes, sir. We have three witnesses.
They've already been sworn, is that correct?
If we want to swear them in again to be sure,
All right, let's swear everybody in one more time then.
Okay.
Probably appropriate. So if you would come forward, Ms. Collins, please. Does anyone have an objection to taking an oath on the Bible? If so, you can be confirmed. All right, hearing none, issue the oath.
Okay. I need each person's name and address, please.
Nancy Collins, 118 Acorn Lane, Point Harbor.
Ben Woody, 153 Courthouse Road.
Robert Brown, 6306 Sandgate Drive, Suffolk, Virginia.
Lauren Berry, 117 Alex Lane, Moyac.
Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes.
Thank you. And before we start the cross-examination, just two other things. We're starting at 5:30. We'd like to wrap it up at 9 o'clock this evening. Is that all right with all participants? Okay.
we'll certainly do our best to get
I think
there.
I've discussed this with the chairman. He's not saying you have to finish by 9 o'clock.
Right.
That
We
what you have
can.
to say, but
I understand
we're
people
gonna-
have places to go.
we will recess at 9 if we're not finished.
Thank you.
Absolutely. And just to make sure, I discussed with Mr. Woody earlier this week to make sure everybody understands, we are following a court order, and we want to make sure that it is recorded correctly by our staff.
See, I thought we had a court reporter here. Didn't
We do
one
have a
last
court
time?
reporter.
Yeah, okay, good, yes. So it's being verbatim, court
Very
report.
good. All right. Mr. Plumley.
Yes. Mr. Woody, first, I just want to say as a general objection, I object to any other material that that's made part of the report, the staff report, that it not be allowed. I think we've covered all the reasons why, but I just want as a precaution to object to any material remaining with regards to the staff report. Now, Mr. Woody,
If I make it clear what that objection means, does that include the illustrations and
Well, I
mapping?
think the board's already ruled, taking my advice.
That's what I thought.
If you have something specific you want to object to, I've requested you to specifically point out. Now, I note, for example, the board did sustain objections on valuations of property. The board also sustained objections on reports from other jurisdictions about secondary impacts. The board sustained an objection of Mr. Woody's competence to testify as to the diminution of property values, of adjacent property values. Those things have been sustained. I do not believe any other objections have been sustained. Did counsel recall that?
I believe that's accurate, Mr. Morrison, but I do object to conclusions submitted as part of the report of staff regarding specifically the secondary effects debate and the findings. I object to that information that's submitted as the conclusory information provided by staff and made part of the report.
All right. My advice would be to the board on these objections, first to tell you that whether a witness is competent or not to render an expert opinion, which could be a conclusion, you are not required to believe the testimony simply because they qualified as an expert. We went over that last time. You can believe all, some, or nothing of what an expert says. In making that determination, you would use your everyday common sense, judge the credibility of the witness's opportunity to know, the witness's training, education, et cetera, whether it is helpful to you. I believe there is evidence before you, and I believe also in reviewing these notes, that it was Mr. Plumley said he objected to Mr. Woody's ability to render opinions on psychological impacts, that sort of thing, of this establishment which is under discussion, but he did not object to him being an expert in land use issues.
Correct.
Okay. So, to the extent that land use issues are before you within his area of expertise, I counsel you, he is qualified as an expert in that, and those opinions or conclusions can be considered by you, and you can give them what weight, if any, you desire. Okay? And so my recommendation is you would overrule the objection of Mr. Plumley on this point.
And may I be more specific, Mr. Morrison,
Please.
with regards to what I did not object to? I did not object to Mr. Woody's conclusion with regards to the content of the zoning ordinance itself. And there's a lot of information that he provides about the zoning ordinance. And I believed he was qualified to discuss that as an expert witness. But the other remaining factors to be determined by this board concerning secondary effects, which, I think one was brought up, quality of life, and we specifically objected to that, and I object to those types of things.
The board has sustained that objection.
That's right.
Okay. So, absent more specificity, my recommendation is that Mr. Woody, having qualified as an expert in land use, can render those opinions. You're not required to believe them, and you can give them such weight, from being the gospel to I'm not going to give it air in a jug. That's up to you. So, again, I recommend the objection be overruled.
What's the feeling of the board?
I agree. That's how I understood it.
Okay. Then we will overrule the objection.
My last statement is, I don't believe Mr. Woody covered the entire report that's been submitted to the board, and therefore I will object to any portions of it that he has not specifically gone over. And for that reason, I have to preserve my
All right,
objection.
you preserve your record. Mr. Woody, you are the author of that report, is that correct, you and your staff?
That is myself and my staff. That is correct.
Okay. As the author of a document which he has authenticated, meaning, yes, I wrote this and I'm offering it for your consideration, it would be my recommendation to the board that this objection be overruled. However, Mr. Plumley is entitled to cross-examine from the entire contents of the document whether or not Mr. Woody actually discussed it in his testimony.
This is a matter of procedure, Mr. Morrison. I've been told that I can only object to the specific things addressed as they're addressed, but he has not addressed significant portions of his report. So if I'm not allowed to give an objection but to those things that are specifically raised, and he's not raised them.
Mr. Plumley, perhaps I'm not making myself clear. I apologize. My concern, since we all know this is going to be reviewed by another body, my concern is rather than just a blanket objection, if there's something you wish to object to, if we have to go through it line by line, then that's, if you bring it to my attention, then we'll rule on each objection in turn. However, I think the law is very clear. The author of a document can submit the document, and then you can cross-examine. Now, you can object to hearsay in the document or other things like that, but I don't know specifically what you're objecting to, so
Let me be specific then, if I could go through those sections. And there's a lot of redundancy in the subjects that have yet to be covered in the report by Mr. Woody. They relate back to a lot of the things that he's already talked about that have already been ruled upon by the board, but I feel as though I have to preserve my objection, or I could be deemed to have waived it, specifically under what's called Section 3, Special Findings Pursuant to Section 808, Judge Jerry Artillett's order. This is page 6 of 13 in my copy that was made available to me by the county. And these are preliminary findings. They address the secondary effects, and they go through step by step and bring into play the same things that have already been ruled upon by this board, the studies from other jurisdictions.
That's been sustained. If this will help you, members of the board, in the packet submitted by the county, you're not to consider anything which would be inconsistent with your prior rulings.
Thank you. Okay, I can get to my cross-examination. Thank you very much.
Thank you, Mr. Plummer.
Sometimes it appears easy, but it's not quite as easy as we'd hope. Mr. Woody, the county has not performed any study specific to mermaids and headlights. Is that correct?
Not necessarily. I assume you mean a study on secondary impacts.
That's correct.
Yes, that is correct.
Thank you. So you've not performed a study about what businesses have opened and closed in the neighborhood of mermaids, correct?
We have not performed a study of that.
Or what residents have opened, or excuse me, have been built, or people that have moved because of mermaids?
We have information in the staff report about residents that have been built and the values, but I do not have information on why they may or may not have moved from a residence.
You have no information regarding crime statistics that you've submitted to the board in that neighborhood of
Other than the
mermaids?
studies we presented, not for that neighborhood, no.
And the studies have been rejected by the board.
Correct.
How many locations within Currituck County are there that have adult establishments operating in them?
Only one to my knowledge.
And that is Mermaids, now known as Headlights?
Correct.
And from that facility, how many persons have been issued adult entertainment licenses by the county?
I don't have the answer to that.
But Mermaids itself as an operation has been receiving a license from the sheriff to operate every year since 2004. Isn't that correct?
Objection.
Basis of your objection, please, Mr. McCray.
Well, I mean, I guess I withdraw my objection to the extent he knows. I would agree he could answer.
Okay, but it also occurred to me what the sheriff has done or not done could itself be hearsay, could it not, unless you have an authenticated document?
I do have an authenticated document. In fact, it's
So perhaps
item.
you could ask the witness to identify that and help him refresh his recollection.
Thank you. Let's see. If you go to tab 7, or excuse me, yes, 17.
It's the same.
Which volume would that be in, sir?
This is the second volume. Tab 17. And I think I have a better copy of this. If you can't read this, Mr. Woody, I'll pass it up if you need it.
Yeah, I don't have the book, so
You don't have
I
the
will
book?
need it.
But for your reference.
I've got it. I've got it now.
Oh, you do, okay. It's very difficult. There is another copy of it, though. Hang on.
We're going to object to this document in any event. It is not authenticated, at least on its face.
If it refreshes his recollection, he can use it to that extent.
Dates it in his paperwork, but they got it every year.
Oh, okay. Let me look at it, just to see it. My copy's very bad.
You see this is a sexually oriented business license?
I think I've got a visible copy.
Oh, you do, okay. Quality control didn't pick that up.
Okay, yeah, that has to come back. That's the only copy we got. Well, all right. What has been presented to the witness, which has not been authenticated, would be, this would be your exhibit number 1, Mermaid's exhibit number 1.
Yes, I'd like to make it Exhibit 1. I've also handed up to the board the order of Judge Height, which I'd like to make an exhibit as well.
All right. What about Judge Tillett? You want, as long as we're at it?
Yeah, Judge Tillett's order, I believe, has
Judge
been
Grant's
presented.
order as
and
well.
Judge Grant's. And those are made part of my exhibits that I
think,
have up there.
I believe a court can take judicial notice of other rulings, so they're in. Okay. All right. For counsel, what Mr. Woody has just looked at is Mermaid's Exhibit number 1. It is a document entitled Currituck County Sexually Oriented Business License is hereby granted to Headlights OBX-Mermaids, Inc., 9098 Currituck Highway, Point Harbor, North Carolina, 27964, with the registering agent Robert L. Brown, issued this 22nd day of April 2015, valid until April 21st, 2016. Signed Susan Johnson, Sheriff, Currituck County, and it's on a delightful.
Copy.
It's just beautifully done. It's suitable for framing. Okay. All right. Now, so I think where we were, Mr. McCray, did you withdraw your objection?
I will at this point.
Okay. All right.
And just to make everybody feel at ease, if you look at page 6 of Judge Height's order, the court has already made a finding that Sheriff of Currituck County issued a sexually oriented business
That is correct.
license
I'm familiar with that.
and
So,
renewed it annually. And the one shown there.
all right, I think that is, his findings are part of the record. Yeah, okay. So, now, if you would direct your question to Mr. Woody, please.
Thank you. Now, Mr. Woody, for this number of years, this has been the only establishment receiving a sexually oriented business license, to your knowledge, is that correct?
I don't have knowledge of what establishment has or has not received this license. I'm not familiar with the license or the process.
Okay, you're not familiar with the
I am
process.
not, no.
Okay. How many acres of property within Currituck County fit all the parameters to operate an adult establishment or sexually oriented business?
I do not have that answer readily available at this time.
And you have not performed an analysis about any other alternative locations for mermaids?
Or have not.
And there is no study that the county has presented for Currituck County about there being any increase in crime in Currituck County as a result of the existence of mermaids for some 20-plus years?
I have not presented that study, no.
And there is not a study that's been commissioned by the county for Currituck County regarding secondary effects of a bar or tavern. Is that accurate?
Not to my knowledge.
And you have made a recommendation that the Board of Adjustment find that there are no secondary effects for a bar or tavern. Is that accurate?
That is my suggested finding, yes.
Now, I believe you and I covered this a little bit in the last hearing, but I want to make clear if you would go to tab 3, what is marked page 24.
Which volume?
Second volume,
Second volume, okay.
tab 3, it's record 24. I'll represent to you, this is your testimony, Mr. Woody. And you can flip back to confirm that this is part of the record. It's been in this case for some time. And you talk about finding number 6, that the board has to make is that the special use will be in conformity with the land use plan or other officially adopted plan. Staff finds that while the proposed use does not conflict with our Unified Development Ordinance, it does not conflict with the adopted land use plan or other plans. That was your presentation in 2010, is that correct?
That's correct in 2010.
And did you modify that conclusion from 2010 until?
I did.
And what did you base the modification on in the interim?
The staff report in 2010 was prepared by a different staff person. Following that meeting, I did the assessment myself. And based on my reading of what I believe was a 1990 land use plan, I came to a different conclusion on the suggested finding.
So another gentleman or person in your position made a different conclusion from the staff's perspective in 2010.
Correct.
All right.
Mr. Chairman, I'd like to ask a question.
Go ahead.
It might be best, if I might
Hold
suggest, wait until his cross-examination is finished, and then Mr. McCray will have the right to something called redirect. We will then entertain questions from members of the board, if you'd be so kind as to make a note of what you want to ask. And then everybody will have a chance to ask questions, again, limited solely to issues you all may have raised.
Thank you, Mr. Morrison.
Thank you, sir.
Mr. Woody, has the county presented to any of the boards in these proceedings in which you participated any study about secondary effects conducted about this specific location?
Not about this specific location, no.
No more questions.
All right, Mr. McCray, do you have any redirect?
I do not.
Now, sir, you may, and any other member of the board may ask questions.
Yes, I was a bit taken back with this placard that the sheriff passed out, and from my brief judiciary training, I understand that the sheriff is not a legislator, and I don't have the authority to write legislation, and it seems like it's conflicting with the UDO. It was mentioned that there's no way we have now of validating that certificate, and I guess my question is, does the sheriff have the authority to, in fact, give out that certificate?
That's an excellent question. The thought occurred to me as well. Was there not something in the UDO on sexually oriented businesses that required the sheriff to issue a license?
There is a sexually oriented business licensing regulation within the county's code of ordinances, which is separate and distinct from the Unified Development Ordinance, which relates to land use regulations within the county.
But with specific regard to sexually oriented businesses, I mean, obviously the sheriff didn't just scribble this out on a legal pad. I mean, it's a printed form. What authority or under what order, and this address this to both counsel, do you ascribe the sheriff's ability to do that, and what is the process by how she arrived at this conclusion?
First, under the sexually oriented business ordinance within the code of ordinances, the sheriff had the authority and duty to issue a sexually oriented business license as well as license to any entertainer.
Did it have to meet certain standards before it would be issued? I mean, you just don't show up and she gives it to you.
Yes, had to be certain standards, but at one point in time, there was no provision with regard to it having to meet zoning standards. That was amended several years ago so that the sheriff would no longer be able to issue such a permit if it does not meet zoning or other ordinance requirements. However, we are under right now a court order which requires the county to allow for this business to operate unimpeded. I can't say why the sheriff has since issued any further licenses.
In Judge Hyde's order, did the judge order the sheriff to issue this license?
The sheriff, along with all county officials.
That's right. Okay, I
boards,
recall. So the sheriff issued this in effect as a result of Judge Hyde's order. Would that be a fair statement?
No, to my understanding, it's not. The sheriff has been providing these licenses to this business since '04 without interruption, except
prior to Judge Hyde's order.
Prior to Judge Hyde's order, up until the business was closed temporarily for approximately 18 months between 2010 and 2012.
All right. The sheriff has been doing this, and so I guess I hope I'm touching your points of interest.
You're there, John.
Okay. But don't we have two different issues before us? The issue that this board is to determine is whether or not a special use or conditional use permit should have been entered, or they have to make findings as if there was an application before them. And the sheriff would not issue, I'm speaking hypothetically, not about this case, the sheriff would not issue one of these permits unless the Board of Commissioners or the Board of Adjustments had previously allowed the application. Would that be correct? And the reason the sheriff has issued it here is it's confusing. It's confusing.
Why the sheriff
It's
issued
just
it.
confusing to me why she issued it prior to Judge Height's order. I understand after Judge Height's order, but I don't.
Again, I would submit that the Code of Ordinances did not definitively provide for a denial based upon noncompliance with zoning regulations.
Okay.
That
Well,
several years ago was again changed.
That has
So
been
that-
changed now, so the sheriff can't do this now.
Several years ago. This was
Okay.
just changed
All right.
in February of 2015 is when it was changed. I mean,
no,
it's
that-
not several years ago.
That's not correct. Mr. Plumlee is thinking about another ordinance amendment that occurred.
All right.
Oh,
All right.
It's 2011.
Last point to touch on any relevance here. Do we know what findings, if any, the sheriff has to make prior to issuing this certificate?
If I may have a moment, I'll be glad to go get a ordinance code book, and we can speak to that. I don't have that in front of me.
Do you have that, Mr. Plumlee?
I don't have the code book for that specific ordinance, but I can see it's holding up the board's thinking.
All right, we can
Wait, here's coming up now, thanks to technology.
okay.
It's sexually oriented business. Okay, you see on the screen, section 8-3-4 talks about a license being required for this kind of business, and then it goes down to begin stating what needs to be provided to the sheriff.
Then what determination does the sheriff have to make, Ike?
That needs to, you need to scroll on some more, Tammy. Well, it talks here at least as 8-35 regarding the issuance. She is to deny it for any of the following reasons.
Could you recite those reasons for the record, please?
The sheriff shall deny the application for any of the following reasons. An applicant or any individual identified on the application is under 18 years of age. Or 2, the application and investigation fee has not been paid. Or 3, an applicant or any individual identified in the application has refused to allow an inspection of the premises. Or 4, an applicant or any individual identified in the application has overdue license fees associated with the operation of a sexually oriented business. Or 5, an applicant or any individual identified in the application has a license under this article which is suspended or revoked. Or 6, an applicant failed to provide the information necessary to determine the qualifications of the applicant or any individual identified in the application for issuance of the license, or provided materially false or misleading information on the application form. Or 7, an application or any individual identified in the application has been convicted of any sexually oriented crime and less than 5 years have elapsed since the latter of the date of conviction or the date of release from confinement if the conviction is for a felony, or less than 2 years have elapsed since the latter of the date of conviction or the date of release from confinement if the conviction is for a misdemeanor. The fact that the conviction is being appealed shall have no effect on the denial or the license of the license. Or 8, the application demonstrates or reveals information showing that the proposed business location or location of the adult live entertainment business at which an adult live entertainer intends to perform fails to meet the requirements of the county's Unified Development Ordinance. That was the provision I was talking about.
When was that added?
Looks like if you look at the history at the bottom, that appears to have been added on or about June 21st, 2010.
Okay, when is the first issuance of this permit by the sheriff's office? Do we know?
2004.
Okay, all right.
And there was one issued in 2010.
Now, okay, so that language that you just read, Ike, that would seem most relevant to our discussion, that was not added until 2010.
That's correct.
All right, and Judge Height's order is what?
2012.
2012. All right. So I think members of the board, clearly the sheriff is under order to do this from Judge Height's order forward. Up until 2010, there was no requirement that the sheriff inquire as to whether or not it had met the land use plan or you had a permit from the Board of Commissioners or the Board of Adjustments. That was added in 2010, and I cannot explain why the sheriff would have issued it from 2010 to 2012. And I think, unless somebody's got some burning questions, that's the fountain of wisdom for tonight.
Well, and I do object to the assumptions being made about why the sheriff acted the way the sheriff acted. The sheriff's not been brought in by the county to testify as to why the sheriff...
The sheriff is not, but you have offered this document.
Yes, but there's just speculation as to why the sheriff
Well,
has
I
done
don't
it.
think there's any speculation after Judge Height's order.
Well,
I mean, he ordered her to do that.
he did not order the sheriff to make a
He
specific...
ordered all county officers, and she's the county officer.
Well,
All right, let's move on
Actually,
if we can.
John, if I could just say, the order's rather specific in what it says. And I've read it about 32 times.
What?
And what it is saying is that the Board of Commissioners is to issue a special use permit or any other approval.
Right, and it also
And it
says,
says that no other county official can take any action of enforcement
well,
with
doesn't it-
regards to the UDO of this
all right,
section.
well, we'll look at that, but that's, now you have offered this as an exhibit.
That's right.
It's not been offered into evidence at this point, but simply to refresh the witness's recollection, is that correct?
That's right.
Okay.
And I would ask one if I can be given the liberty of asking one more question, Mr. Woody.
Surely.
Mr. Woody, you talked in your presentation about the heavy industrial locations for these sexually oriented businesses. Is that correct? Or you discussed the fact that they must be located within a heavy industrial business district in the county. Is that correct?
Correct. With the issuance of a special use permit, they're limited to heavy industrial zoning districts.
So they also require a special use permit to be in those districts as well?
Correct.
Okay.
All right, I will, to the extent it helps you, as you'll recall, we reviewed in chambers, we reviewed an executive session, closed session, prior to going into this, the various court orders. And Judge Height made a finding in a court order that the sheriff had been issuing these permits. So that is an order and that is a fact of this case. Okay? All right. Now, any other questions from board members?
I'm not sure that my question actually got answered, and I may have asked the wrong question.
No,
John.
you asked the correct question. I think it is we don't know.
Very well.
Okay. Any other board member have a question? All right. Is that all for this witness, counsel?
Yes.
All right. I think it would be appropriate at this time, members of the board, I believe there's at least one individual in the public that would like to testify. That is Ms. Collins. Ms. Collins, good evening. My name is John Morrison, and I'm serving as counsel, as attorney to the board, not for either party. Let me explain what we're doing here. It might be helpful to you. This is what is known as a quasi-judicial hearing, meaning it is analogous to a court as opposed to a political meeting. And I don't mean anything negative by the use of the word political. In political, you can just say, I like it or I don't like it, and that's fine, and everybody pay attention to it. In a court setting, which this is, your testimony must be competent, it must be substantive, and it must be relevant. Okay. Don't be intimidated. You go ahead and say what you want, but I just wanted to let you know if there are objections, okay, I'll advise the board that's what it is. But basically, you need to tell the board things under oath based upon your personal observations.
Right.
Now, you may have expertise, I don't know. If you do have expertise, then you can render an opinion on certain things. If you don't have expertise, you cannot. However, you can talk about your personal situation, how you've been affected or not been affected by this. Okay?
Well, thank you.
All right. Thank you, Ms. Collins.
My main concern is the noise level.
All right. Well, let's get some background first. Where do you live, ma'am?
I live in the house that backs right up to the club.
All right. So your property is adjacent to the
Yes.
club property. And is it a residence? This is your personal residence. All right. And how long have you lived there?
I've lived there since 2006.
All right. And who else lives in the house with you?
Right now, just me.
All right. And where are you employed, ma'am, if you are outside the home?
I'm employed at Dominion, North Carolina Power. I've been there for 35 years.
And what is your position with Dominion?
I'm an administrative assistant to the manager.
All right. Go ahead.
Oh, okay. Thanks for allowing me the opportunity to voice my concerns. One of the main concerns is the noise level. It gets noisy. I've had to call the police department several times. When I first moved into the house, I found pornographic pictures in my backyard. There's been trash. I have a 7-year-old grandson that's at my house quite a bit, so I'm concerned with him seeing things of that nature while he's playing in the backyard. I've had kids trying to get over to the club, maybe to peep in the windows, I don't know what for, but I've had to put a security light in my yard to light up the yard so that I'll know who's in my backyard. There are kids in the neighborhood, so I'm certainly concerned with the other kids, seeing things of a sexual nature, pictures and whatnot in our neighborhood because of the club being there.
All right.
And that's pretty much
All right.
it.
Just one last thing. All this is being transcribed by a court
Oh,
report.
okay.
Just to make certain. Everything you've just testified to is based upon your personal observation. Is that correct?
Yes.
All right. Thank you. All that the witness said is admissible, in my opinion. And there's been no objections. All right. I guess what we would do is, since the county has not rested, you can go first, Mr. McCray. Do you have any questions of this witness?
Yes. Ms. Collins, you lived there since 2006. Has the club regularly operated since 2006
No.
from your observation?
When I first moved in, I was told by my real estate agent that they were in the process of shutting down, and there was hardly anyone there.
So can you describe a time period or time frame during which you observed no operation? Or
I guess it was between, like they said, 2010 and 2012 when it was closed down completely. I thought it was closed for
I'm
good.
going to object to what they said.
Yes, that
Just
objection
the
should be
hearsay.
that objection should be sustained. If you do sustain it, you should not consider what the witness just said as to what other people told her.
Sustained.
what did you observe during the period of 2010 to 2012?
I'm objecting to the form of the question.
That objection should be overruled.
It was not open. during that time
You
period.
saw no lights? Did you see any lights on?
No,
See any cars in the parking lot?
nope,
Any persons coming and going on a
no,
regular
not
basis?
during that 18-month period.
And did you then notice a difference in the noise level coming from that property during those 18 months?
Well, there was no noise coming from there. They weren't open.
And did you find that you had a different enjoyment of your property then versus
Very much
now?
I'm going to
So-
object to the leading nature of the question and form of the question.
All right, if you would please, Ike, just for the record, but I know leading questions or objection in Superior Court, but we are a little bit less formal than that. Let me put it to you this way. Ms. Collins, during this period of time, can you describe how you've enjoyed your property, if there's been any interference or if there has been no interference with the enjoyment of your property?
Well, during that time, I could sit on my back deck. We could cook out in the backyard, play games in the backyard.
And subsequently, when the business was operating, what difference was there, if any?
We don't use the backyard
Why?
because of the element that's next door.
Could you?
The noise,
Okay.
the partying.
All right. Thank you.
More questions?
Are you able to differentiate between employees and patrons of the establishment?
No.
I don't have any further questions.
Mr. Plumley?
Yeah. Tell me again your address.
118 Acorn Lane.
There was just a brand-new home built at 121 Acorn in just 2014. Is that correct?
Yes.
And there have been other folks that have moved into the neighborhood while this club has been operating. Is that correct?
Yes. But that home has been on the market for some time now, and they've not been able to sell.
Have you met with Mr. McCree prior to today?
Is that Mr. McCree?
McCree is just asking you
Oh.
questions.
Have I met with him?
Have you
No.
spoken to him on the phone?
No.
Have you spoken to anyone from the county prior to today?
I called in and I believe I talked with that gentleman.
Mr.
Or
Woody?
left a message or about when the hearing was going to be held and that type of thing, but that's all.
So you've only spoken with Mr. Woody in the past about this matter?
Right. And I think I left a message. I don't know that I really talked to him. I think I
Okay.
left a message.
Okay. Have you attempted to contact the club and speak to the owner of the club?
No.
Have
He
you-
did come to my house, and I guess he wanted to do a survey or whatever, and I told him what I thought of the club at that time.
Okay. And when was that?
I don't remember the exact date, but he was coming through the neighborhood, and he came to my door.
All right. Have you talked to your neighbors? Have you brought them out to come and meet over here today?
Mr. Foreman, when he was alive, he's passed now, but he used to come, and he used to talk to me about the club all the time. And also Gwen, who she's passed also.
And nobody else?
I did talk to the Homeowners Association's husband, and they were going to try to be here tonight, but something must have come up.
No more questions?
All right. Thank you. Any board member have a question of this witness? All right. Thank you then, Ms.
Thank
Collins.
you.
Thank you.
Ms. Collins, you are free to stay here or leave as you choose.
Are you finished, Ike? Is there any
Yeah,
county side?
county has nothing further.
All right. So the county is rested. Mr. Plumley?
All right, we'd like to call Lauren Berry. Ken? Ms. Berry, can you tell the board your name and your occupation, please?
My name is Lauren Berry. I live at 117 Alex Lane in Moyotte, North Carolina. I'm a commercial real estate appraiser.
And you've performed a study with regards to residential, it's a market analysis and a comparison of residential values in Currituck County associated with this nightclub.
Yes, sir.
If I could pass out her resume and her report.
Sure. Would you like this marked as
Next exhibit, yeah.
Exhibit 2?
I believe it's 3 and 4.
All right. Madam Clerk, if you'd be keeping tabs on this. Would you show those to Mr. McCrae before you circulate them to the board?
Now, you're a commercial real estate appraiser, that's correct?
Yes, sir.
And you're certified?
Yes, sir.
How, you have a master's degree in business administration?
Yes, sir.
And how long have you worked in the appraisal industry?
13 years.
And are you familiar with the area of Mermaids?
Very much so.
Okay. And did you review the sales and transactions of homes in the county recently?
The last market analysis I did, I believe, was in
May of 2015?
May of 2015. I have not updated my research.
Okay. But you conducted a study also in 2010 of this vicinity?
Yes, sir.
All right. Can you describe your method to the board of what you were trying to do?
Pretty much what I did is I went through and looked at South Currituck, Grandy, south to the bridge. Tried to decide what overall price per square foot I could find. Of course, you have different neighborhoods and they represent different values. But just in general, here's how much is selling, here's how much it's selling for. And then I broke it down to this neighborhood, I believe in a 100-foot buffer and then a 500-foot buffer. And then the 1,000-foot buffer, because there's not that many lots. And you have such a small sample size. You kind of have to take into account the whole neighborhood. People don't discern between 750 and 500 feet. When I was looking at that, I was trying to decide if there was any difference. If I could see, if I looked at this subdivision compared to another subdivision in the county, was there less building? Was the price per square feet? Was the days on market higher for this area? And I couldn't tell the difference.
Now, first, I would like to tender this witness as an expert in the field of market analysis and performance of market study for this purpose of this hearing.
Mr. McCrae, do you have any questions or objections?
No.
All right. Members of the board, the curriculum vitae, that is the resume, and the witness's training, education, and experience are such that you could accept her as an expert in this field to render opinions regarding value. And it would be my recommendation that you do so. Is that the point you tender her for?
That's correct. And market analysis, a
And
comparison
yes.
of values throughout the county.
Comparative values market analysis. Again, if you accept her as a witness, she can render an opinion. You are not required to believe the opinion. You can give it, you judge that by the same way that you would other witnesses, except that she can render an opinion.
Now, Ms. Berry.
Well, just a
I'm
minute.
sorry. Yes.
So, Mr. Chairman, the motion before you is to accept this witness as an expert. It is my counsel that you do so. So the record will
Yes.
reflect that she is received as an expert.
Thank you. Ms. Berry, the documents that have been presented to the board, the curriculum vitae and the report, did you prepare those documents yourself?
Yes, sir.
I would move to introduce those documents into evidence for the board's use.
My recommendation is that the board receive the documents.
They will be received then.
Ms. Berry, you have given the opinion that there is no difference in market value. Can you go through some of the details with the board, specifically with your report?
Of course. You look at absorption rates. You have a lot of subdivisions. If that, they develop a lot slower. If there was, let's say, Mermaids was causing a negative effect on development, there wouldn't be the buildup. People wouldn't move in. You'd have higher transitions or transaction rates because people would come in, they'd want to leave and find another home. I didn't see that.
Objection as to what people might do or not do.
These are things I'm looking for.
You're objecting to,
Objecting to testimony that relate to why people are moving in or out of a neighborhood or why they're staying there for any period of time.
Well, perhaps we could rephrase the question, counsel. If
You're
nobody objects, let me just see if I can cut to the chase.
You-
Based upon your personal observations of people moving in or out, is that sufficient information with which you can draw a conclusion that would be accepted by professionals in your area of expertise?
Alone, no.
All right.
It's.
Well,
I think I answered wrong.
Okay, all right. Then the objection should be sustained.
all right, sustained.
All right, can you provide the answer?
Yes, okay, let me explain this a little bit better. When I'm looking at this neighborhood compared to the overall market of Currituck County, I did not see an increase of transactions showing people moving in and out. I didn't see a depression in absorption rates.
What do you mean by absorption rates?
Absorption rates is how fast a development is built up. Is it 2 houses per year? Is it 10 houses per year? It might be the difference between Shingle Landing and Moyock and one in Grandy. Shingle Landing has a higher absorption rate. They're building quick. In Grandy, you've had the same lot sitting vacant for 20 years. What I was looking at to see if there was any difference in this market compared to the overall Currituck market. And because I didn't see those transactions, the price per square foot is in line. The days on market, how long it's been advertised, I didn't see a discernible difference there. I am an unbiased opinion of this market, so I'm just looking for any differentiation. And that's what I was saying. I did not see any.
And what time frame were you looking at sales going forward to the present, approximate present?
2010 through 2015, and then I did look at absorption rates from 1995 through 2014. I think those are the years that are on our GIS. I was just trying to see, when the houses actually popped up, and then I went back and saw if it was a resale or if it was a new addition. And that's just one of the things I looked at. Pretty much I looked at all the houses' histories, including recent transactions and transactions in the past. I think my information goes all the way back on that subdivision to 1997.
And did you see any trending with regards to homes being built in the direct vicinity of Mermaids over time?
And are you talking about the 500-foot buffer, the 1,000-foot buffer, or are you just talking about?
Well, either. If you want to start with the
neighborhood?
500-foot buffer, and yes.
I do not have it broken out that well. I do see from the largest increase is between 2003 to 2008 in that first 500-foot buffer.
All right.
And then again, there's another increase by just another house in 2012 And from my understanding, there's also been another house in 2014 that was built.
All right, Ms. Berry, I have no more questions.
All right.
Just so I understand, you compared what you call the absorption rate of that area compared to the county as a whole?
Yes, sir.
You were specifically looking at, was there a change in absorption rate over a specific period of time?
That was one of the aspects I looked at. I also looked at price per square foot as well as vacant lot sales. What your report is a very short synopsis of my findings. It doesn't look like much because I was just trying to make it pretty easy to understand. I looked at actually all of the lots, looked at all of the different sales from 1997 to 2015.
I want
when
to
did the
clarify one
report.
point. You're talking about the mainland, not the island.
I'm talking about South Currituck, not even including Moyock, because Moyock is a whole different market. It's a sub-market in Currituck.
Okay, that's a little more specific. So South Currituck being from, I'm sorry, South Currituck being from Coinjunk to Point Harbor, or?
I think I did Grandy South.
Okay, Grandy South. Okay.
Any other questions?
I don't think so.
Anybody else have any questions? Yes, Ike?
Other than the board or you, I mean, I'd like to ask a few questions.
Sure.
At the appropriate time.
Yeah, it's appropriate.
Ms. Berry, what's a comparative market analysis?
A comparative market analysis, pretty much where you are telling someone, well, comparative market analysis or a market analysis?
Comparative.
Comparative market analysis is looking at two markets and comparing them overall.
And what type of analysis is it when you were looking at similarly situated properties, such as you would look at this particular entity headlights in this neighborhood, and then do a comparison of a similarly situated neighborhood adjacent to a sexually oriented business? What type of analysis would that be in your field?
That could be a comparative analysis. I did not actually appraise mermaids. I have not put a value on this business or building. I was actually looking at it's a subdivision analysis pretty much.
So you didn't find a similarly situated subdivision with a sexually oriented business adjacent to it and do a similar analysis to see what, if any, impact there was?
To my knowledge, there's not one.
There is not one. You did not do one.
Well, to my knowledge, there's not another subdivision next to this type of business.
Nowhere?
I mean, of course there is in Elizabeth City, but Elizabeth City is a different market than Currituck.
Okay.
As far as, I do not know of another neighborhood that I could have done that. I would have liked to. That would have been great, but
In Currituck County, you don't know of any other neighborhood.
no, sir.
But you didn't look for or study any other similarly rural county with a subdivision adjacent to a sexually oriented business.
No, sir, I did not.
I don't have any further questions.
Just a couple of redirects.
Redirect.
Ms. Berry, you in fact found a higher per square value for this subdivision than you did the subdivision further away from the business. Is that correct?
I do not recall that.
I think it's on your report.
Hold on. Sorry,
This is the area.
yeah, that was the average market of Currituck.
That's
And
right.
this is the average market of this neighborhood.
Of the 500-foot?
Yes, this isn't a
Excuse me.
separate neighborhood.
So if you can explain
Yes,
that.
okay.
I'm
All right,
trying
yes,
to
okay,
make that
yeah,
clear.
sorry,
It's
all right.
quite an important
Yes,
point.
all right,
Yeah.
all right. Your first line of the report states the average price per square foot, which was $110.63 for overall South Currituck. In this neighborhood, you're in the 1,000 square foot buffer or foot buffer
1,000-foot
area
buffer.
is $125.68 per square foot.
All right.
But it's not a different neighborhood. It was county to this.
Thank you.
Sorry.
No, that's-
Any other questions from any members of the board? All right. I would assume that you have this witness on the clock, so unless anybody objects, you are excused. You don't intend to, nobody intends to call her back? All right.
If I may ask, who is paying for your appearance tonight?
My appearance is paid based on no matter what I say. It's Mr. Plumley. However, it's an unbiased.
You've been retained by the applicant in this matter, is that correct?
Per hour, yes, sir.
No further questions.
All right. Thank you. Well, I have one question. I see you went to East Carolina.
Yes, sir.
Yeah. Why did you guys fire Ruffin McNeil?
That I'm not an expert on.
He's the best football coach you've ever had. All right. Thank you.
Thank you.
Appreciate it. All right, our next witness, is Bob Stebner.
Would you spell that for us, please? His last name.
Come on. And I don't believe he's been sworn in, so he'll need to be sworn in.
All right.
I'm Bob Stebner, S-T-E-B-N-E-R.
You need to be sworn first, sir.
Oh, I'm sorry.
Madam Clerk, if you could, or Madam Chair, Mr. Chair, if you could issue the oath.
Do you have the Bible there?
Yes.
Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. Would you spell your last name for the court reporter, please?
S-T-E-B-N-E-R.
Thank you. And give us your address, please.
I live at First Flight Storage. I'm general manager of the property
In Currituck.
in Point Harbor,
Okay. Thank you.
And what is the address at First Flight?
9086 Currituck Highway.
All right.
That's the property right next to Headlights. That's the long buildings.
Okay, so it's up on the screen right now, next to the red outline.
Yes.
And how long have you been working at First Flight Storage there at that location?
This is my 16th year.
And in addition to working there, do you live at First Flight Storage as well?
Yes.
And it's a part of your duties to remain on the premises most of the time,
Yes.
and including at nighttime as well?
Yes. We advertise open 24 hours.
And have you had any encounters, negative encounters with mermaids or the patrons or persons at Mermaids, employees?
No.
Have you had any complaints about its operation?
No.
Have you noticed any litter or pornography or anything of that nature coming from that place?
No.
Have you heard any loud noises coming from Mermaids?
No. Where I live is the end of the long building, and then there's a space, and then there's another building. I live right at that corner.
Okay. And in your work there and your living there, you've not had any reason for any disturbance, heard any disturbance coming from Mermaids? Is that
No.
accurate?
In the years, all the years I've been there, I can't even think of an instant that there was a problem, an incident or anything like it.
Generally, have you encountered with your patrons, is there a lack of vacancy, people not using your storage facility, or is it used?
Oh, I'm 98% full.
Okay. And that's people coming and going from your facility at all hours of the day and night?
Yes.
Have you received any complaints from anyone about Mermaids operation?
No.
I have no more questions.
Hi.
When people call me.
Well, just a minute, sir. You can only make a statement if you ask a question.
Well,
So-
if I could say, I mean, he is here as a resident. The last resident did make a statement at the beginning of her presentation, so if he had something that I didn't ask him about and that he would like to, he's a member of the public, I would think he could state
All
it
right.
if it's admissible.
All right. I think you're correct. Go ahead, sir.
Thank you. People call me especially if they live in Dare County and they want to know where exactly are we located. And I don't hesitate to say right next to headlights. And then everyone says, oh, I know exactly where you are. I've never had a problem with it.
All right.
Mr. Stebner, I assume no one else but you lives at this storage facility, is that correct?
Yes.
So it's not a residential use of property, it is a commercial storage?
Yes.
And you live at the northernmost end of the property, adjacent to the other storage facility company?
This is First Flight Storage. I live right here.
Okay, so you
If you come onto the driveway, you make a right, and my office is right there. The driveway's right.
Is that the icon on the building in which you live? You see this
Yes,
little
yes,
hand there?
yes, and
Okay.
closer up this way to the corner right there.
Okay, so you got a pretty good buffer between you and headlights, do you?
I'm going to object to the form of the question. It's leading and
Well,
argumentative.
It is
cross-examination.
He gets the lead and cross.
My suggestion is the objection be overruled.
I've overruled my own objection, John.
All right.
Mr. McCree, please continue.
So you have a pretty good buffer there between where you live and headlights, do you?
Yes.
Okay. And you don't actually have a clear view of the headlights property or building, do you?
I can see the building, not the whole building, not the
Right.
entire
In
building,
fact, you
but
probably see what the,
but I can see it.
and you probably see in the top back of the building. Would that be fair to say?
More of the rear, the stairs, and the rear end of the building.
Right. You don't see the parking lot, do you?
On this side, yes, I can, because the parking lot's kind of big, and I can look down this way.
But you don't see the parking lot directly in front of the building itself. And,
No,
and the door, and
it's blocked by the
And you
building.
can't see the doorway in which patrons enter and leave.
No.
And so you don't really have an ability to know what transpires on the property, do you?
I'm going to object to the form of that question.
My suggestion is the objection be overruled.
You don't have any ability to really know what is going on that property
No,
when the business is in operation, do you?
no.
Now, you've been there 16 years living in it?
Yes, sir.
Is there any period of time in which, to your knowledge, the headlights or mermaids was not in operation?
There was a period of time, I don't know exactly when, but there was a period of time when no one was in the building.
Now, were you here for Ms. Collins' testimony a few minutes ago? There was a lady that testified a little while ago. Were you here for that?
No, sir.
Would it be fair to say that to your knowledge, the building was closed for a period of about 18 months?
I would say, yeah, probably.
All right, I don't have any further questions.
Now, Mr. McCree just stated that you have no ability to know what's going on over at Mermaids. Do you think that's true, that you couldn't tell what's going on at Mermaids from where you are?
Not from where I live, no.
Okay. But have you had occasion to witness what's going on over at Mermaids?
I've been in Mermaids.
Okay. And have you been outside of your building and seen people driving in and out of the parking lot at Mermaids?
Oh, yes. I walk the property, I drive around the property regularly.
Right. So you have plenty of chances to observe what's going on at Mermaids.
On the outside, yeah.
Maintaining the building.
Yes,
Doing work at the storage facility.
yes.
Mr. McCrae suggested that it's not residential use that you're making out there, but it is your residence. It's where you live.
It's where I live, yes.
Okay.
I don't live in a storage facility, it's an apartment.
Okay.
I don't live in the,
Right. So you have an apartment there.
Yes,
And during your times of work, you're walking the entire property, correct?
yes.
And at that time, you have plenty of opportunities to observe what's going on at Mermaids. Is that right?
On that side, yes.
Okay. And when you're making those rounds about the storage unit, do you hear noise coming from Mermaids, loud noise?
Not loud noise, no.
Any kind of disturbances that you've heard coming from Mermaids?
No.
All right, no more questions.
All right. Any board members have questions?
I have one.
Yes, ma'am.
Are you a paid witness or a volunteer?
I'm not paid, no, ma'am.
Anyone else? All right. Then, Mr. Chairman, I would suggest, as we've done with the other witnesses, Mr. Stebner's free to stay or go as he chooses. Thank you, sir.
Thank you.
Thank you very much.
Thank you.
Thank you.
Thank you.
We'd call Mr. Robert Brown. Mr. Brown, can you explain to the board who you are and what you do?
Yeah, my name is Robert Brown. I'm the president, owner of Headlights Mermaids at 9098 Currituck Highway.
And how long have you been an owner of Mermaids?
I've been an owner of Mermaids since 2009.
All right. Now, at this point in time, I want to make known to the record the exhibits that we have and that I've presented, and I'm going to proffer to this board and attempt to introduce. First, the next exhibit, which I guess would be Exhibit 5, are the record of proceedings. This is tab 2, Board of Adjustment, this board's proceedings, which were the subject of Judge Height's order. Second,
We would, you want to hear my objections at each exhibit, or do you want to?
I think so, yes.
We would object to admission of applicants or petitioners exhibit number 5 for a couple reasons. First of all, they're not relevant to this proceeding before this board. That particular record related to a notice of violation, code enforcement action, and issuance of civil citations that occurred around the time that matter was appealed to this board and then to the Superior Court. While it is included perhaps within Judge Height's order, you would note that in Judge Height's order, he strikes the decision of the Board of Adjustment in that matter in its entirety and remands the matter back to this board and to the Board of Commissioners to do several things. First of all, to accept the application, an amended application of the applicant, which was done, and then secondly, to make certain findings as set forth in Judge Tillett's order. Judge Tillett's order has to do with secondary impacts analysis, as you've seen in Judge Tillett's order, related to the original intended use of this property and the amended use of this property, that being the original bar, nightclub, and now the sexually oriented business or adult entertainment establishment. Again, we submit that these documents are not relevant to this matter before the board, and as provided for in the rules of evidence with regard to relevancy, it is a waste of this board's time and will cause nothing but confusion for you to delve into the record of a matter that has nothing to do with Judge Tillett's order and is not before you tonight. That would be the basis for our objection.
Okay, Mr. Plumley?
yeah, this is relevant material. This is material that pertains, there's a lot of testimony in this record about how Mr. Brown came into contact with the county, that he was allowed to amend his ABC permit to include mixed beverages, how he met with the county manager, met with Mr. McCree, that forms were filled out indicating that the location was in compliance with the zoning ordinance, that there's information in this record showing that Mr. Brown relied upon that information given to him, that he made some $250,000 of improvements to the facility based upon that information that was given to him, and he relied upon that the findings of Judge Height tied directly into the debate going on at this hearing, that the county had maintained throughout the hearing that they had no idea that Mermaids was even operating. I mean, if they're going to tell us that it has secondary effects, but they didn't know simultaneously that the location was even operating, I think that's contradicted. Their information is being contradicted by this record. In addition, Mr. Pastor, who has testified as an expert, reviewed this information. This was part of the support for his testimony. And for these reasons, it's not only relevant, it should be included in the record for consideration by this board.
Mr. Plumley, don't we have I mean, the board's going to give you all the time you need, but if this comes into evidence, it's not just going to be a stack of paper sitting up here. We're going to have a recess, and it looks like, to me, the board is going to have to review, am I reading correctly, 800 and some pages?
Well, that's just for that one proceeding. That's just the Board of Adjustments proceeding.
Okay.
There's
All right.
also the Board of Commissioners proceeding, which is the next exhibit, which should be reviewed as well.
And I'd submit we would not probably object to that, as that was that was conducted within the parameters of Judge Height and Judge Tillett's orders.
Well, if I may, Ike, I'm also talking about the Board of Commissioners meeting from 2010 as well as the one from May of 2015.
I would submit that that is even more relevant than the particular record that the petitioner is trying to have admitted at this point in time. Again, that record that the petitioner is attempting to admit has nothing to do with the matter before this board tonight, has nothing to do with the parameters set out in the respective judges' orders with regard to what this board and the Board of Commissioners was to do on remand, and we object on that basis.
I don't think there's any understanding what Judge Height did without seeing this record, without understanding the testimony that was given by the county. This county maintained through several sworn witnesses that they knew nothing about the operation of Mermaids during the time that Mr. Brown came to see him about all these requirements for the ABC board.
Well, I would
And
submit,
Judge Height specifically found that they knew about it, that they knew all of this at that time. And to say now that there's secondary effects when they were previously telling everybody sworn testimony that they knew nothing about it is it's contradicting the
All right.
presentation of the
All right,
county.
all right. I think I understand the arguments. Mr. Chairman, I would ask, we've been at this about an hour and a half. I'm going to have to look at some things. Could we have a
Recess, is that what you're asking?
well, long enough for me to review 1,400 pages? 15 minutes.
Yes.
15.
Okay, thank you.
All right, we'll break for 15 minutes.
Thank you, Mr. Chairman.
That'll be record time.
I'm a speed reader, don't worry.
Good luck with you. No. Thank you very much.
I know. I shouldn't say this, but every time I come here, there's some kind of problem. And so far, no problems. This is just one of those buildings that,
Yeah, but it does it to us a lot too.
there's a building in Richmond that we used to always swear that happens. The heat doesn't work?
Old building.
God, it's working good tonight. It
Yeah,
was working
actually.
good last time we were here too.
How are you doing today? Hanging in there?
Yeah,
good. Right, yeah. I'm doing all right.
Well, but you don't get to look at
Well, 15 minutes.
So you don't get to look at it and consider it and then decide if you're going to elect. No, we will accept it into evidence. Doesn't mean we're approving it, doesn't mean we have to.
accepted in evidence,
Yeah.
then I want a copy of it.
Okay.
I'm not gonna approve something, I understand I can't go down before I approve.
Now, you understand, accepting it as evidence doesn't mean you have to agree with it.
But I'm not gonna.
They're allowed to submit stuff to evidence, and then you weigh out the weight of it.
I can't weigh all the weight of it if I don't know what it is.
Right. But you have to allow it to come in before you can.
Yeah, right, I understand that, that's what I'm talking about, I'm talking about if we allow it, then I want copies of whatever we allow. Because
That's
at
reasonable.
at the end of this, we're gonna be making a decision, and I want to be able to see the evidence I've made decisions on. You know what I'm saying?
Yeah.
At the end,
Well,
when we
when you
make
make
our
a
final
decision, right.
decision,
Right.
this will be a piece of, if we allow this will be a piece of evidence. Right? It will be an exhibit, if we allow it.
It could be an exhibit.
If
Anyway, I mean, it's.
you allow this to be part of this proceeding, then part of our decision, our final decision at the end, will be based on this being done. Right? Yeah, well, I understand, I don't have to accept it.
Okay.
But
Not me.
What you're saying is, if we accept it, you won't get a copy of it.
Yeah.
Have access, so you can take.
Well, thank you very
Right.
much. Exactly. I just.
Then we'll make sure it goes.
I have a hard time approving things that I haven't seen.
There's nothing easy about what we have to do.
Right,
We'd like to think of it as being easy or simple, and it's not.
it's not, and if he wants to present an 800-page documentation, then I want to have access to that.
Supposedly, John is reviewing it as we speak.
Yeah.
Johnny Carson, you hold it up to your head and you can
There you
see
go.
right through it.
The front part of 2,000 pages.
John,
Yes.
am I right or am I wrong? Are we doing this as if this were a new application?
I think so. That's compared to what I want to look at. Mr. Chairman, it might be helpful if you and any other board member wants to come in and say, let's go into, I think, attorney-client consult with you.
Okay, so I'll have to call for a.
No, you don't have to.
We're in recess.
We're in recess, and you always have the right to consult with your attorney. We'll announce what we did when we come out. So,
Okay. I thought we had to announce it before we go into closed session.
well, you have the right to consult with your counsel.
Correct.
All right, let me look at this first, and then I'll come out, and then we may have a closed session.
Okay, yeah, I'd rather
All right.
do it right.
No, and I'm feeling, you know, and I'm feeling uncomfortable at the end to we're gonna make a decision on things that I haven't looked at, and that's.
Well, trust John will stuff what's on his course.
Right, and I do,
But look at it this way. This is something, an experience you get that will carry you on through.
Oh, yeah, there
Because
won't be any
come
particles up
December,
there.
I'm gone.
There won't be any
Okay.
particles.
And you're
Oh, I
gone.
wouldn't be on that.
Well, I'm gone in December. And you'll be moving out into.
Why are you leaving?
My second term expires.
You can only serve a two
terms.
Oh, two consecutive.
Two consecutive terms, right?
Gotcha.
So I'll.
And there were three of them then. Now it's down to one.
Too bad.
I'm tell the judge you got to keep.
Now I got, yeah, you're right about that.
I look at it.
Well, I mean, he answered the question. It's just a guy.
Fortunately for me, I would have to attend a lot more meetings over 2 years where we used to have it.
I've just finished 1 year. I think over the summer,
We used to have them.
yeah, and then that's when they changed the,
Right, and so you You've not had the exposure to that when I was at your.
I don't think there's been but maybe three.
Did you break it? Why?
And then Mr. Faces, the one before this. Trying not to drink it. So I know where you're at. Actually. Pepperoni pizza is there.
Right.
In some instances, more commissioners can I ever watch.
My dad used to be on this board years ago. Who was your dad? John Lawrence. Oh, my God. Yeah. Everybody knows him. He drives the school bus now, right? No, you got him mixed up. He used to be chairman of the school board. Yeah, John Lawrence is board for. Yeah, I remember that. 30s, 40s years. Lord, no, you don't want him on a school bus. Nah, no, different one. Yeah, he said he started on this board. This is his first board. I used to be on, sports director. Terms there.
This was an experience for me. I got a call one night about 5 years ago. I asked if I was serving the board of adjustment. I don't know, what's the board of adjustment?
Yeah, I know. Yes, asked me, I was like.
What is that? A lot of people don't know.
Now you gotta say no. Excuse me.
I had told him
No, I
I was
actually
interested in
did.
being on another board when I got booted off for the time on the other. He called me.
I actually did some homework, man, and I said, well, let's go.
Well, my first degree was political science.
Okay.
And I worked at Commonwealth Attorney's Office in Virginia Beach for 7 years.
Oh, you got good training.
You could move over to the planning board then.
Well, the
Yeah,
planning
I
board,
like all that, but I-
no, this is more demanding than the planning board, I would think, because you sit as a court.
That's definitely more than me.
Okay, we're back in session now.
Mr. Chairman, I would request to confer with the board in closed session, council to discuss legal issues. We will not deliberate on the merits of the case, but only on the legal issue.
Okay, everybody all right with that? Okay. At this point, then we'll go into closed session.
Mr. Marsden, I might suggest that you just have to make that the appropriate motion
Yeah.
to enter closed session for the record.
Closed session to confer with council.
I'd like to make a motion that we go into closed session to confer with council.
Do we have a second?
I second that motion.
All in favor?
Aye.
So he couldn't read all 14.
2 minutes, bathroom time, it's almost. Okay, I'm gonna run to the bathroom.
200 each meeting.
Yeah, I may be changing my mind about my lottery attorney. My lottery attorney. Remember I was gonna hire a personal lawyer after I won the lottery? Remember the whole discussion, I said, I was gonna hire a personal attorney to advise me on my millions and millions of winning, and I'm doing more.
He's got experience actually fighting over lottery tickets.
But I may, maybe dead by the time I get, actually spend my lottery with it.
I didn't really intend for, when I voted to roll the money over, I meant save the $60 for the next big pot. I didn't mean for Bill to go out and buy tickets for $75 million, which we got nothing.
Yeah, he needs to like drop that down to like $2.
$2 to get in?
I mean, I'm definitely rooting for Carolina, but.
Not everybody has 2 kids in college and medical bills are the eating.
It's so fast coming around the corners. I mean, the Patriots could do nothing.
Yeah, it's interesting. I make a lot more money than most of the county employees, but my wife doesn't work with no choice, so we get like the household income of actually
I thought they just
pretty
swept by
regular.
Pittsburgh.
Yeah.
Pittsburgh.
I don't always think about that
I
though.
felt the same way. And plus all those receivers miss all the passes.
I'm stuck in the house.
They drop them about 10 pretty.
I got a little bit of that going on too. Not like you, Brian, but I'm not, equity's not where it needs to be.
Pittsburgh.
Yeah, I know.
That's negative, but it's not enough, like, it's not enough, I couldn't go to another house immediately.
Damn market crash at the beach.
We went up to Ravens Stadium.
Killed everybody
I didn't
down
know
there.
it was a real casino right next to the stadium in Baltimore. Ravens Stadium. And there's a horseshoe casino next to it. It's Holiday Inn Express.
So tired tomorrow.
Holiday Inn Express.
G&T coming in 10:30 and treat.
Nice.
Always a point in time for that stupid retreat.
The Harbors Inn. It's Holiday Inn.
Either.
Harbor Inn is yeah.
We don't have to do much tomorrow though.
Skins will have a good year next season, I think. They don't.
But the trade off at the end at 4:30, like, man, doing this.
Fire the coach.
Good, I mean, it's like too big, it's depends on how, if they're engaged in the land use plan, it'll take a while, if they're not, then it won't. And that water line is a pretty big topic too. Oh, we've done it like 4 times.
That's my team.
And Paul Bell's game on Saturday, maybe others decide they want to bail too.
I think we're running out of steam.
They were like
Playing
11
stuff.
straight before they got beat. You know, it's odd how that happened this year. I think they were 1-5, and then they won.
That commercial on the beach would probably deal with that, I'm guessing. 'Cause like even last retreat, it was on these beaches got dropped. Next time he's gonna double feed or make a motion to double feed, have a tour operator license. Bob said next.
He's gonna flush him out.
Yeah.
He started jacking it.
Do you want water?
Oh, no, thanks. I actually brought water this time and
Okay.
brought a drink. I was much more prepared.
Yeah.
Keep going on the screen. Okay. And this one.
Oh, I'll show you what that is. I think it's that one right there. It's one of those
Just
two
across the
lots.
street?
Yep.
Okay.
One of the board members gonna laugh out of the, one witness and was like, yeah, I've been in there all the time. So I chuckled. I had to laugh too.
Oh, yeah, yeah.
I thought he, like he was, you were asking him like if he'd been in it. He was like, yeah, I've been there all the time. Like nothing,
You know, take your witnesses as you find them.
What'd you
Yeah,
say?
I said you take your witnesses
Oh.
as you find them.
Yeah, it was great. He was honest, you know.
He was
It
honest.
was great.
Okay. I've got to steal some of
Oh,
these.
go ahead.
I'm gonna have a vote
This is
election.
your, I don't know if they told you yet, but the city ordered a copy.
Oh, Chesapeake
of
here?
your- Yeah. John Lynch ordered the original.
Oh, he finally ordered it, did he? Oh, good for
Finally
him.
did. Good for him. So the, city.
So I can get a copy.
Yeah, well, the city's getting a copy, so you're with the city, right? Aren't you all one?
Yeah.
So yeah, I can send you a copy. too,
Okay,
then.
good.
Definitely. Now, if I have to print it, pay, charge for the paper, but
You
if
have to
I just
print.
email it
Just
to you,
email it.
I can do it for free.
Cool.
Chesapeake, yeah, you do a lot of land use work in Chesapeake?
Mm-hmm.
With the city usually, or with the,
With the city.
Okay. No, they don't have an arm of attorneys at the city of Chesapeake?
They've got about 10 or 12.
Yeah.
We do all the environmental work.
Okay.
Remember Camden and the landfill?
I do.
I represented them on that.
Okay, yeah. A lot of land, a lot of like development. I was reading, saw a pilot article the other day about all the subdivisions and lots, but.
Oh, yeah.
From Chesapeake?
Yeah, but it's amazing is we've got
Crazy.
we've almost got the same, not the apartments, no, knock that out. We've got the same numbers here in Moyoc. We've done,
There's all the people in Virginia
we've got
that
about 1,000
want
lots that
space.
have come through the office in the past like 2 or 3 years, so very.
How are those lots building out? Are they, okay with drainage? Is that an issue?
So far they've done pretty good. The absorption rate's been good, drainage has been good. Now what's gonna be the test is this past 18 months, we've improved a lot with really small lots, and those haven't really started coming to record yet, so that's gonna be the key. So the smaller lots come.
See
Well,
what
if
kind of.
people gonna buy it. I mean, if you live in Modoc, you want more land. I
Right.
know. Then all the other impacts.
So you're saying if there's a higher ratio of impervious, that you may start to see a few
You may.
drainage issues?
You may. We have a really we have a very rigorous stormwater ordinance at Currituck. But
Yeah.
it's probably one of the more restrictive ones in the state. So you have to do a lot. But the soils in Modoc are really bad. So as I'm sure they are in parts of Chesapeake.
Oh, they are.
Bad.
Terrible.
Yeah.
They are in Virginia Beach. I mean, I live on fill material.
Do you? Yeah.
Oh, yeah. It's horrible.
And when you get down to lower Currituck and the beach, it's like fantastic. The water just go home.
No, that's why my neighborhood, we've got a low spot in the road.
Yeah.
It's really the road sinking is what's
Yeah.
happening. And the city has not come out to put new asphalt down, but they're going to have to put maybe 2 feet of material.
Wow.
That's a lot of sinking.
Lot.
It's just this, I mean, you can tell, it was just a swamp,
Isn't all of Hampton Roads effectively sinking?
Yeah.
More or less.
I think that's right.
So that's why everyone's coming to Currituck.
Maybe.
To live.
To the hot spot, get 14 feet above sea level. That'd be interesting, like, for the future of that community is having to deal with, like, sea level, or like, sea level rise, and the fact that it does appear that that area is kind of settling. I don't know the technical word it is, but it is having some issues. So
Mm-hmm.
I think it's some major infrastructure challenges up there.
Oh, yeah.
All beyond
Public
your
infrastructure it's going forward is going to be a big challenge.
It's-
And it's unconstitutional to charge developer fees down here?
It's not a constitutional issue, it's just that the cities and counties don't have the authority.
Okay, so the legislature is not granted the authority to do it?
So we can
Except
charge
in certain
can
limited
charge-
circumstances.
parks and recreation fee in lieu of, so you can set up where we do that. You require a land dedication for park or recreation or a fee. That's kind of like a fee. Utilities, you can charge impact fees for utilities, but in terms of just schools, fire, police, all that stuff,
Well, the cities up there were all happy to charge these big developer fees,
Yeah.
and the developers were paying it. Well, then all of a sudden, the state said they couldn't spend the money to make improvements to schools.
no.
They could only use it to build a school. I mean, that takes a lot more money.
Wasn't there a developer recently up there that offered to like add an addition to a school or something?
He did. That was a very recent thing, and they turned him down, and I thought the drawing was pretty cool that he submitted, but this was one of those projects where the developer didn't get great advice, pushed it forward, and then at the last second threw this Hail Mary, let me try this, didn't even bother to call the school board, to talk about building a new building onto their school,
Yeah.
which they'd probably like to get, give some input on.
Yeah.
So I think they just sort of put him off more than anything, said, you're probably a year away anyway, just come back and
Yeah.
if you've got that kind of money to throw around.
Well, that's interesting that they can collect fees but not use them, only use them to build a school.
Yeah, they can't use it to like fix the air conditioning or, all the kind of repair and maintenance that you'd want to be able to do on these schools, they can't use the money for that.
Yeah.
And the cities went crazy, but I think that was really some of the other developers around the state lobbying in Richmond to make it less attractive to take the money,
Yeah.
to disincentivize it. So.
It's tough. Real strong home builders lobby in North Carolina, so it's just difficult to do things like
Break
impact
through.
fees or anything related to that. So
Well, I think development down here appears to be going at a steady pace, but not an obscene pace. You know, South Chesapeake, sections of Virginia Beach just came up like overnight. And we were left without much infrastructure, you know.
yeah,
Roads are bad, the schools are overcrowded.
that is true. There's parts of Virginia Beach, especially, you can tell they probably weren't prepared for what they got. So. Yeah, we do okay. We're managing it, but it's brisk in Modoc. It really is.
Well, the paper today said home sales were up for new homes, way up in December.
Yeah.
And there had been a drop in new homes in September, but in December it just, you know, there was some huge percentage increase in 1 month in new homes. So I would imagine people are pulling permits and, you know, getting ready to dig and build.
Yeah, we issued those building permits this in 2015. Wasn't quite, it actually was close to like 2006 levels. So like our from 2006 to 2015, the curve just goes exactly like that's like a U. So it's getting back to where it probably was when things were okay. So in Modoc at least, dead down there. Lower Currituck, nothing happening down there. But
There was an article recently about the Outer Banks, the lack of hotels.
I saw that. Yeah, I saw that in the pilot over the weekend.
I represented an old hotel down in Dare County years ago, the owners of it. And Colonial Inn, I think. Like, I think it was like 10-mile marker or something. It was over by the fishing pier. And I think it was only about 38, 40 rooms.
10 would be about Nags Head, Good Over Hills line right in there.
I was thinking like the Avalon Pier is like Moppo 6 or something. So
Maybe that's right. It's been a long time since I've been down there. They were going through a business divorce, you know, the partners in that, and I handled that for a couple of years, and we got it straightened out, and then they sold out of that. They made a fortune selling that thing. And the family that sold it went off and got into some subdivision over here right in like 08, you know.
worst time.
And it just leveled them. All the money that they had, it just zipped. It was gone. They called me up like when the damage was done. I'm like, well, horses left the barn, you know. You need a different kind of attorney now. Yeah. But I guess there haven't been a lot of new hotels being built in the Outer Banks.
Not in the conventional sense. Giant houses that have 20
Well,
bedrooms.
Ives built that Hampton Inn up there close to Duck or Pine Island.
Yeah.
That was, what was that, 8 years ago maybe, or
No, it's
Probably more
longer than that.
is it longer than that?
Yeah.
Probably 15 years.
Like up to 15.
Oh, wow.
It's probably the last one.
Has it been that long? Oh. That's a really nice place. I've stayed in there. I
It is
thought it was
probably
really
the
cool.
nicest Hampton Inn there is, I'm guessing.
chance he'll just say, we gotta read this 800-page document, so we gotta reconvene another day?
I think they ought to say it's not relevant to be done with it. We've already gone through that matter. It's been
Oh,
in
okay.
Superior Court. Judge White struck it all and said, the county can't enforce any of this.
So that's what they're apparently discussing.
Yeah,
Right,
to
okay.
me, that matter has nothing to do with you were in that. Actually wrote it, I said.
Yeah, I didn't hear it, but I wrote it. You don't really get what's going on until you write the transcript up. It's odd. You're not really hearing the words, you
And then
just,
we just keep carting the same pile of papers around. It's just,
is this the last board, or is there gonna be another one?
no, this is the last one. And Brian and I agreed, after the commissioners had their hearing in May, and we would hold off till the Board of Adjustment had their hearing, try to have the orders adopted about the same time, so both the matters would just go up together to
Right.
Superior Court.
Right. So that's the next step, is Superior Court.
And then I guess the Court of Appeals.
Yeah, our Superior Court, I think, is our circuit court. I think that's what we call circuit.
Yeah, I think that's right.
Do y'all have general district, or do you call it just district?
Club District.
Yeah, that's what I thought.
It's all within the general, what's called the General Court of Justice.
Oh.
You have the Superior Court Division, District Court Division. Our District Court Division deals with all juvenile,
Yeah.
domestic matters. You all have a separate.
No, we have a
court.
separate, ours is, just criminal, traffic, and civil that are
Our
under
our
Superior.
district does criminal, civil, typically less than $15,000,
Mhm.
and all juvenile and domestic.
Oh, well,
Ike,
that's the
did you ever
same.
do any domestic work? in your
I
practice?
represented social services agencies for 15 years, did
Did you really?
abuse neglected cases.
But you didn't do custody
Tough
out in
work.
private practice or anything, divorce work?
Matter of fact, I only did land use, and although I did do some adoption stuff and guardianship for elderly.
So up in Virginia, now when I practiced years ago in Carolina for several years before I moved to the beach, I did domestic relations work. And to think of it this way, in Virginia, it's the equivalent, they do have J&DR courts and juvenile and domestic relations courts, but they also hear all of it in the circuit court division. So it's like having a superior court judge sit over all of your custody and divorce. I mean, it is unbelievable.
What's this Court of Chancery thing? What is that?
Well, they finally got rid of the
Rid of that.
technical Court of Chancery, but there's the law of equity and then there's the law. So any kind of equitable claim went before the chancellor. Okay. Who was still the judge, he was the chancellor. Well, they kind of got rid of some of those distinctions, but you still have those equity divisions.
That wasn't me. That was not me.
I thought you were reaching out to me.
No.
Blame the county. Sitting in Paul.
Step up.
All right, everybody is here. We are back from recess. Before we went into recess, Mr. Plumlee has submitted the large document.
It's identified as 11-CVS-113 Record of Proceedings.
Okay. And asking that that be accepted in as evidence, and the objection has been made by Mr. McCree, and after consideration, it's the chair is leaning as to sustain the objection. How does the rest of the board feel?
I
Agree.
I agree.
Okay. Then
The objection is sustained, Mr. Chair. I realize this may be important to Mr. Plumlee. He feels strongly about it. The clerk should be directed to preserve this as part of the record. It could go up on appeal, and Superior Court could decide whether we should have considered it or not. Okay? So, Mr. Plumlee, if you will make sure that the clerk has this, it's in the nature of what we call an offer of proof.
That's right, and we've proffered this exhibit, and right now it's under tab 2 of the materials that have been provided to the board.
Very good. Thank you.
All right.
All right.
We also moved for the board to consider the record of proceedings
of the Board of Commissioners. This is dated, the proceedings are dated in 2010. I think the order came later. Let me make sure I'm looking at the right. This is record of proceedings for 00 CVS 134. And this was submitted, this is both the transcript and the exhibits submitted to the Board of Commissioners back October 18th, 2010.
All right, Ike?
While I would question the relevancy, I mean, I would submit that it does relate to the litany of proceedings that have gone on through this matter with regards to issuance of the special use permit.
But is that really relevant to us?
Well, I guess I would say it probably looking right at the judge's orders is outside the bounds of what the court's instructed this body to do, which is to consider the application before you, first of all, and secondly, to make certain findings relative to secondary impacts, and that record certainly had nothing to do with that.
Well, is there an objection or not?
I would object.
Okay.
And I'm just addressing that objection.
Yes.
This is a relevant proceeding, and it does, there are a lot of discussions about this particular nightclub, and a lot of discussion about the 2006 decision of the Board of Commission to drop the lawsuit against Mermaids. This goes back to 2006, that the Board of Commissioners voted on a vote of 4-1 to drop the lawsuit, and what impact that had on Mermaids and the people working there and the investments that were made there as a result of that vote.
All right. Mr. Chairman, my advice would be to sustain this objection and again preserve the record.
May I ask a question about it? Okay. The items you were just speaking to, I think we were already presented that in other documents. Is that correct?
You have the court's ruling with regards to certain facts that were brought up. We have a witness here. We're going to address some of those things directly, so you will hear some of it. But there was a discussion with the Board of Commissioners directly on the question of their previous vote 4-1 to drop their lawsuit with Mermaids in 2006. So that's a lot of the discussion in here. Also, Mr. Woody made a presentation at that time in which he stated that it was it did comport with the land use plan of the county, and there's other relevant information, which is, you know, it's several hundred pages. Let me see. Maybe not so. It's 247 pages or 48 pages of material.
Is all of that needed for us? If there are certain parts of it that would get the points you need to in, as opposed to the...
Well, it's been objected to. I do want to proffer it and preserve it for the court to decide whether it should have been accepted, because there's testimony given during that proceeding that won't be duplicated here tonight. So that's why I believe it's pertinent to these proceedings. But if the objection is sustained, I'm asking that it be preserved for the Superior Court to rule on that.
Then
our charge is to view this as the application as it was originally submitted. Is that correct?
Well, your charge is to consider the application from 2000 and to make findings about secondary effects specifically. And there are discussions in this proceeding about the use of the property, what was going on at the property, and whether or not there are secondary effects, I think, is part of that discussion as well. So that's why I believe it to be relevant, just as I believe the Board of this very board's record to be relevant as well for consideration.
Just if council can help me be clear on what our charge is, because you're telling me on an application submitted in 2000, Judge Tillett is saying rehear it as if it was the original submission. If I can just be clear from council, all council, what is it you want this board to consider?
Let me take the first whack at that, and that's an excellent question, sir. The last order is from Judge Height in 2012, and if you go to his decretal portion, that is his orders, the findings of fact and conclusions of law contained in the Board of Commissioners September 21st, 2011 order are reversed, and the matter is remanded forthwith to the Currituck County Board of Commissioners. All right, that doesn't concern us. That's the Board of Commissioners. And to the Currituck County Board of Adjustments for proceedings and findings not inconsistent with this order and Judge Tillett's order of May 99 and Judge Grant's order of 2006. Okay, then the rest of the provision is directed, of the order rather, is paragraphs 2, 3, 4, and 5 are directed to Currituck County, that they're not to interfere, that they're to issue certification to the ABC board, that they're to rebate the fines, and et cetera. All right, so then I think from that we go to Judge Tillett's order, because that's basically all with regard to us. That is all that Judge Height is doing. He's saying carry out Judge Tillett's order. And Judge Tillett then says the matter be remanded to the Board of Adjustments for rehearing. I would take rehearing to mean starting all over anew. And that the Board of Adjustments consider petitioner's application pursuant to sections 1304 and sections 808. He then says the petitioner is to file and the county is to accept a new application for a special use permit. And that was done into the year
May of
2000.
1999.
That was done in 99.
And the
Okay,
application was made in 2000.
all right. Well, no, I'm getting, the order was in 99, but the application was made in 2000, right?
That's right.
All right.
Or it was created by the county and submitted and accepted by the county in 2000. I believe.
All right. Which would be in accordance with.
Of course, the county didn't create the application.
Excuse me, I'm sorry. It was submitted and then accepted
All
by
right.
the county.
So that would mean that paragraph 2 of the order has been complied with. All right. So then it would seem to me that.
Of which order? Of the
Of Judge Tillett's order.
Tillett's order.
So that would then mean that what this board is to do is to consider the 2000 application, and they are to in addition to considering that application, you are to make specific findings under section 1304 and specific findings under 808, maybe under 808, because as long as we're on this, if council would help me, if you would look at Judge Tillett's order, paragraph 4 under the decree. Is everybody there?
Mm-hmm.
Ike, are you there?
Yes.
All right. Help me with this, and I'm not arguing, I'm truly trying to understand. The Board of Adjustments in the alternative shall consider the petitioner's application pursuant to section 808. I could read that as if you don't want to do 1304 in the alternative, you could consider 808. You can do one or the other. Or I guess I could also read it, you could do both. What is your, do you understand my point?
I think the county has been going forward and staff's been going forward all these many years with the impression that it was to do both. But I do
Plumlee,
see
is that-
what you say.
I think
The alternative would connote you can do one or the
you
other.
could do one or the other. But I do want to point out how,
Could we address that first, just so?
well,
Does everybody,
this is-
do
this
both
is-
council want us to do both?
I do want both.
All right.
That's what I want.
And that's what we'll do. All right.
But if I can, there has been an assertion that this board can't issue a permit. I believe
No, what, this board, I think we've beat that horse. This board has stated, and I think it is correct, that they don't have authority to issue special use permits. However, the court has ordered us to do that, and that order was not appealed. So we're under an order to do it, and we'll do what the judge's order says.
Well, and I just wanted to point out a factual matter, and that is, it's also a fact of this case that this board issued a conditional use permit for this facility.
Okay.
But
All right, well,
this
but there was a
particular facility.
dispute as to whether they thought they were issuing it for a topless establishment or not.
And we submit that's dead and gone.
Okay.
With the new
Well, wait a
application.
minute. I'd like to keep some kind of order here, and we're getting off track. All right. Then we jump forward to Judge Grant's order, which is my favorite order because it's one page. And it says just go back and do what Judge Tillett told you to do, right? Okay. So that's the way I'm advising everybody. Are we all on the same page on that? Mr. Plumley?
I would like, frankly, to be heard on a larger level, John, than bits by bits.
All right, well, you have a chance to make an argument.
I have a full presentation to
Okay.
make to the board.
All right. We will do that. Okay. Any commissioners, or excuse me, board members, any questions about what I've said?
No, but I think we deviated a bit there.
We did.
Okay.
I don't like that.
I think the question was whether to accept this proceedings as an exhibit, this proceedings.
I was responding to one of the board members' inquiries.
Right.
All right, and I think where we left that is my advice to you was to sustain the objection to preserve for the record the exhibit.
And by doing so, that would be there when it goes to the next court level.
We
And
contend that we did not conduct the hearing properly because we didn't consider this. And then the judge would have before him what it was we didn't consider, and he could make the determination if it was relevant or not.
at this point, I'm inclined to sustain the objection. What does the rest of the board feel?
I concur, Mr. Chair.
Yeah.
I'm in agreement.
I'm in agreement.
Okay. Then the objection is sustained.
Madam Clerk, the same precautions, you'll preserve that for the record. Okay.
This is known as 11 CVS 134 Record of Proceedings. It's the next exhibit. And it's in tab 3 of the notebooks provided. The next exhibit is the May 5th, 2015 transcript of proceedings before the Board of Commissioners, which it was purported by the county to be in response to Judge Hyde's order, that hearing was held.
How many pages is that, sir?
It's the transcript alone is tab 4 of the second volume. And this transcript, while it has a long index in the back, it's about 150 pages. And that includes discussion, argument of counsel, and testimony.
All right.
I don't have any objection to that.
All right. Well, if there's no objection, it comes in.
Yep.
Now, we've got a significant problem. You've offered into evidence a 150-page document. These folks have taken an oath to perform the duties of their office. We only have one copy of this up here. There is no way they're going to be able to review that 150 pages tonight.
I do have multiple copies for them, by
Okay.
the way, just as an
All right.
information.
We're going to need those, and it would be my recommendation that we're going to have a recess for everybody to read that. Otherwise, it's just a futile thing, and it would be a violation of your oath. You're not considering the evidence before you.
I think that makes sense.
All right. So, and you've offered them in this sequence. And normally, one bit of evidence supports the next. We could, I guess, go forward with the remainder of your evidence, and the board could go into recess to review this. We come back in another week or two or whenever, and then we could hear closing arguments. Is that the way you would like to proceed?
I would
Or
like
would
to
you-
proceed if we could, since it's about 8 o'clock. It may be best, if there's no objection, Mr. Brown will be available. I have no more witnesses other than Mr. Brown.
How long will Mr. Brown's testimony
It could take some time. I think well beyond the hour and 15 minutes
All right.
that we have, and I don't want to break it up if I can avoid that.
All right. Mr. Chairman, it is in your discretion to keep us in session as long as you wish, or it is in your discretion to grant a recess for the obvious reasons before the board. And the chairman alone can grant a recess. You may wish to inquire what other folks think.
Yeah. May I ask one other thing about
Surely.
the evidence? Are there going to be other parts of it that Mr. McCree may object to? And should we put them all in and read them all at once?
Now, as it stands now, Mr. McCree did not object. It is in evidence.
This part is. I'm
Yeah, this
talking about
last-
other.
the last part.
Transcript.
Right, transcript.
And because I want to make a point clear, because this board has refused to consider studies, a number of these following exhibits were our counter studies to the studies being presented by the county, and I'm assuming the ruling would be identical as to my studies.
If it came in without objection, which it did.
It did not.
No, we sustained the objection not to.
No, I'm talking about your counter studies, whatever's attached.
I didn't submit just now, John, my counter study.
Okay, well,
I
there-
submitted the transcript of the proceedings only.
All right, okay, that's what all right, good. Then it's not yet before the board as to these other documents you're talking about, and I don't have an opinion whether it be an objection and whether it be sustained or not. So, we're really digressing here. Mr. Chairman, or you had some more questions, I think, or?
I guess the only discussion I have is, at this point, are we going to allow the time for him to depose his witness?
Well,
That's what you're asking, right?
What I'm asking is that we recess now so I don't have to break up the testimony
Gotcha.
of this witness
Okay.
at a later time.
Well, and I appreciate you bringing up the point. Are there any other exhibits that you want us to consider since?
Yeah, excellent point.
Yeah, that's what,
that's what I was trying to get to.
I can go through
Come
that
back
very
in 2
quickly.
weeks. We don't have to do this again.
Right.
Yeah.
If I can go through the rest of these.
Yeah. Why don't you and Ike, Mr. Chairman, if you could give them 5 minutes and they can discuss what other things he wants to introduce and whether or not they're going to be objections or not.
I mean, if he's
Okay.
going-
We're gonna go-
If he's going down this list, I'm ready to make my objections right now to each item, to the item.
Okay, good. All right.
Okay.
I'm going to go down this list. I have a few others that are just specific to this witness that I can go through with the board at this point or wait until this witness comes back to testify.
The witness is going to be used to authenticate them or explain.
right.
Well, then we can't rule on that. Authenticate means I'm the author or I'm familiar with it and such reason. Okay, so we couldn't address that.
All right. So these next 4 exhibits are counter studies to the county's studies that were rejected by the board, not accepted. And so I'm taking it that the board is going to have a consistent ruling about studies, about other locations, and And in fact, these are critiques written about those prior studies. And
Well, if there are critiques written about something that wasn't accepted, I fail to see the relevance.
I'm not going to move to admit
Of
them.
course would object because they're hearsay.
All right.
I'm not moving to introduce
All right,
them.
you're not moving them into evidence. Okay, let's
Okay.
move along then.
So I'm moving down to number 9 on this list. This is a list of expenditures made at the location since the court's ruling in 2012, when the court ordered that these hearings be held as early as possible. That was Judge Tillett's ruling, as early as possible, and they were not held. And on a reliance that they would continue to be able to operate, they made expenditures of $106,000. And this is this tab 9 is the receipts and information detailing those expenditures.
Couldn't the witness just testify to that himself?
He can. This is backup support for his testimony.
Well, I would suggest we wait till we get to the witness on that point.
All right. Ms. Berry's already submitted her report, so that's not needed. We have the receipts for sexually oriented businesses for 2004 to 2009, but that fact has already been ruled on by the court. We have the order of Judge Tillett, which I believe the board has.
The board is going to take judicial notice of Judge Tillett's order.
We have Judge Griffin had a related order that I have in there as well, and I have Judge Grant's order and Judge Height's order. I take it all that's admissible.
Yeah, the board has already reviewed all of that.
Okay. The 2016 sexually oriented business license has been amended. 18, Mr. Morrison, these are replacement documents for the record of proceedings that this board has decided not to accept. The very first record of proceedings, the big one, that the board had sustained the objection on. These are replacement pages because there are many pages that were illegible as they were submitted as part of the record.
Okay, well, just preserve those for the record. The board's already ruled on that.
I preserved those replacement records. And then we have the CV of David Pastor, who was the witness, and I believe he identified that, and I moved to introduce that CV.
That CV should be accepted.
All right, the rest we'll save for our final witness.
All right. Mr. Chair, are you inclined to grant the recess at this point?
I am, but I'm going to ask one other thing before I do that.
Yes.
Mr. McCree's cross-examination of the witness, his objections to the witness that was here earlier. Can we proceed with that and make...
I don't believe that witness has concluded his testimony, has he?
I think the chairman is talking about the
Mr. Pastor.
Expert witness.
from last time, but I thought that you ruled on objections as we went through the testimony.
Yeah, you did. Mr. McCrae cross-examined him.
And I did.
And obviously can't cross-examine him tonight.
Okay.
So that's been tended to.
So that's already...
I think so.
Yes, okay. What we will need, though, before these members leave tonight, if we've got them available, this lengthy exhibit that has been received without objection, every member needs a copy. I'm going to need a copy. Ike's going to need a copy, and the clerk's going to need a copy.
All right, we have those copies.
All right, good.
Okay. Well,
All right, now do we also agree on the record that the board can study this exhibit at their leisure outside of this hearing? Is that agreed to, sir?
It is with agreement of the admitting party.
Ike?
County agrees.
Okay. Prior to your recess, Mr. Chair, I again advise you should not discuss this among yourselves. The deliberation must be in public. You should not do any investigation. You should not attempt to gather evidence. You should not talk to any of the parties or their witnesses or anybody else about this. You may review evidence that has previously been submitted and received. And if the clerk has something you want that was introduced into evidence, you can look at that. but don't discuss it amongst yourselves.
Okay, and when we go into recess, when we do reconvene, we will then be going over this part that is...
No, you won't. You can ask questions about it at that time, but it's in evidence. And so, if he chooses to emphasize something or not, we'll take it up then. If you have questions about it, you can ask then. Or it may be there's just nothing to do but move on to the next piece of evidence.
Be then the presentation of your, Mr. Brown, okay. All right.
We need to also set a date.
Discuss a time we're going to meet.
Should we be concerned about the preservation of this document?
That's
The clerk will do that.
Very well.
Can we have it on note too that any other future documents that are going to be presented, that you always have a copy for all board members, please?
Yes. We do have that for all board members here.
Okay.
There's nothing
have
that
to
we've handed
accept
up
it
that
in
we didn't
the
have a
evidence.
copy of everything.
Right.
Okay.
Just if it is accepted, so we all have copies.
But in fact, right in that corner are boxes of those same notebooks. I just didn't want to pile that information in front of you at this point until we came to them to
Thank you.
address it.
That's
That was
perfect.
the only.
Thank you. So are we looking at a date?
How long do we need?
Well, what's the will of the board, and what do, I guess some of it will be up to the attorneys as to their schedule also.
I wouldn't mind taking the opinion of some of our legal counsel that does a lot of this reading stuff. So if we could get an opinion, I would treasure that.
I would think it'll probably take you a good 2 hours to review what is you're going to be taking home with you.
2 weeks.
2 weeks?
2 weeks.
What day is
How
that?
long did you say?
Do we have to do it on a Thursday?
Yeah, and that's sitting down and not doing anything for that.
Of course
No,
not.
sir, you can do it on any day you
Most
choose.
don't have that lifestyle.
If I may, I note that your next regular meeting would be February the 11th, the second Thursday in February.
So that would be 2 weeks from now, wouldn't it? Yeah.
Is that already a full agenda, or is there nothing?
Is
I
there
don't
an
know. Do we
agenda?
have
Is there
anything?
anything on the agenda?
No, sir.
Sounds good to me.
I'm going to make a suggestion, February 11th.
I'll second that.
Do we want to meet earlier than the scheduled time of 7 o'clock?
30 again?
5:30, is that?
Yeah.
I'm okay with 5:30.
Mr. Morrison, do you have any conflicts?
No, sir, I do not.
Woody?
Okay. So then we will be taking a recess and reconvening February the 11th at 5:30. Any objections?
Would it be possible to get a copy of the transcripts up to this point?
No. We are in recess.
Ones that